Why is preponderance of evidence so hard to define? Imagine trying to balance a scale with one hand holding a handful of different objects. Some are heavy, some are light, and you're asked to decide which side is more convincing. That's similar to what the phrase preponderance of evidence involves. It's not about counting pieces of evidence or measuring exact weights. Instead, it's about which side appears more likely to be true based on the quality and credibility of what is presented. In civil cases, the goal is to show that one side's story is more convincing than the others. But what makes this tricky is that it's not a strict math problem. It's a judgment call made by the judge or jury. They have to decide if the evidence tips the scale just a little more in favor of one side, more than 50% likely, that the claim is true. That's where the difficulty begins. Because more likely than not is a vague idea. It's not about absolute proof but about which side seems more believable. Think about it like this. A single, clear, honest witness might outweigh many witnesses whose stories are fuzzy or inconsistent. Or a signed contract with clear terms might carry more weight than someone's vague opinion about what was meant. The fact finders, judges and jurors, must judge the credibility of each piece of evidence, which can be very subjective. They consider how trustworthy the evidence is, how reliable the source, and how well it supports the case. This subjectivity makes it hard to pin down a precise definition. Unlike a mathematical calculation, it's about feeling, perception, and judgment. That's why two different judges or juries might interpret the same evidence differently. They might see the evidence as just slightly tipping the scale in one case, but in another case, they might see it differently. This ambiguity influences how lawyers present their cases. They try to make their evidence as convincing as possible, knowing it only needs to be more believable than the opposing sides. Judges instruct juries to look for that slight edge, just enough to say one side's story is more probable. But even with instructions, jurors bring their own perceptions of what, more likely than not, means. Because the standard is about convincing someone that something is more probable, it's inherently flexible. It's not about proving something beyond all doubt, like in criminal cases. Instead, it's about persuading someone that the evidence makes a claim more likely to be true. That's why defining preponderance of evidence precisely is so difficult. It depends on human judgment, perception, and the subtle art of persuasion. In the end, it's a balancing act that relies on the quality of evidence, not just quantity. This makes the phrase tricky to nail down with a simple, clear-cut definition. Instead, it remains a flexible standard that depends on how convincing the evidence appears to the fact finders in each unique case.